Good afternoon, everyone. And thank you for joining us for our webinar this afternoon on tips for collecting and paying child support. My name is Jessica Steingart. I am a staff lawyer here at the Centre for Public Legal Education Alberta, or CPLE for short. You'll see some other faces on your screen, and I'll introduce them in just a moment. But I'm going to go through some introductory remarks first, and then we'll get into the meat of our presentation today. So first, I'd like to acknowledge the land on which we sit. So the Centre for Public Legal Education respectfully acknowledges that we are located across Treaty 4, 6, 7, 8, and 10 territories. And we respect the histories, language, and cultures of the First Nations, Métis, Inuit, and all First Peoples of Canada, whose presence continue to enrich our vibrant community today. And a quick disclaimer before we move on. So we are here today to give legal information. We are not able to give any legal advice today, but we're hoping we can give you as much information as we can about collecting and paying child support. And of course, I'd like to recognize our generous funders, which make presentations like this one possible. So we receive, CPLE receives funding from the Alberta Law Foundation, the Department of Justice Canada, and the Alberta Real Estate Foundation. A few more housekeeping items before we move on. We won't be circulating today's slides, but good news is we are recording this presentation. So in about a week and a half, you can expect to find the recording up on our YouTube channel, and we'll send you an email when that is ready so that you can go back and take a listen or share it with others. We ask that you would save your questions till the end. We are going to leave some time for questions. Throughout the presentation, you're welcome to post them in the Q&A box on your screen, but just know that we'll save answering them until we get to the end. And finally, when you leave today's webinar, you'll be prompted to complete a short survey, and we really appreciate you taking about 30 seconds to fill that out to let us know how we did. Okay, so a little bit about who we are. So who is CPLE? What do we do? Well, our mission is quite simple, and that's to make the law understandable for Albertans. So we are a nonprofit organization. We serve all of Alberta. We provide legal information and education through our various booklets, videos, info sheets, webinars, websites, and more. So webinars just like this one. And our goal is to make the law available and understandable so as to empower Albertans to actually use the law, understand their rights, and to take action for themselves. This is our website, our main website, cple.ca. And so you can see the breadth of legal information that we provide. So while we're talking about child support here today, we do provide information about a variety of other topics as well. Okay, let's dive in. So today I am so excited to introduce our two panelists. We are very privileged to have them joining us over the noon hour. So I'll introduce Adam and Gail. So Adam Benarzi is a family lawyer at Benarzi Law. Adam is a sole practitioner practicing exclusively in family law. Through his firm, he runs a legal relief program, which attempts to bridge the gap for those who don't qualify for legal aid, but who cannot afford full representation. Adam's focus is to help clients who are on the difficult end of a power imbalance between the parties, whether that's a financial power imbalance or a history of domestic oppression or violence. At the core of Adam's practice is the theory that child support should be easily obtained by the recipient party. His legal relief program is especially designed to ensure that those entitled to receive support do receive it so that they can be lifted out of their difficult situation. So thank you, Adam, for joining us.
Thanks for having me.
Okay, and next up is Gail. Gail is the training coordinator with policy, legislation, and communications with the Family Support Order Services branch at Alberta Justice with the Government of Alberta. So Gail has been with the Maintenance Enforcement Program for 24 years. In a team lead role, Gail supported several units with the focus on developing and implementing strategic and measurable steps to achieve desired operational changes and outcomes. With her extensive knowledge of the program, she currently serves as the training coordinator. managing, developing, coordinating, and conducting training activities for the maintenance enforcement program. Through facilitating these training activities, she has successfully transitioned current and new staff, as well as external stakeholders, to achieve their learning objectives. So Gail is sort of a MEP expert, and we are very pleased to have you on the call as well. Thank you, Gail.
Thank you for having me.
Okay, so we're going to go through a series of questions, and Adam and Gail are going to provide some exceptional information, I'm sure. And like I said, after we go through our formal questions, we'll leave time at the end for questions from the audience. So let's get started with the first question. A very basic question to make sure we're all on the same page and we know, what the topic is that we're here today. So the first question is, what is child support? So what is it? Who pays it? When does the obligation start to pay it, etc.? And I'm going to hand it over to you, Adam, to tackle this one first.
Okay, what is child support? So child support is if you're separated from your spouse and if you have care and control of the children for at least let's use the example 60% of the time. You look at the other party's income, and it's a whole question of determining what their income is. There's a calculator that you could find online. You plug in some numbers, how many kids there are, what the income is of the payor parent, and the province that you're in. So that'll generate a amount that you're meant to receive in what we call Section 3 child support or base child support. Now, on top of that, there's something else that we call child support, and more precisely Section 7 child support. And that deals with anything, specific categories outside of, let's say, food and shelter, clothing. So outside of that, there's categories like out-of-pocket medical expenses and extracurricular activities and insurance premiums paid towards the benefits for the health expenses, post-secondary school, extraordinary school expenses. And so all of that falls under this category of Section 7 child support. And those expenses are divided between the parties, and the way you figure out how it's divided is you look at the income of the parties and you turn those into percentages. So if you're making more money, you end up paying more of a percent of the Section 7s. If you're paying less money, you end up paying less of a percentage of the Section 7s. I'm not seeing in the slide some of the sub questions you raised. Just I want to make sure that I'm hitting all of them there.
Yeah, who pays? And maybe you could also just elaborate on when the obligation to pay starts and stops.
The easiest example, so there's nuances on both of those, but I'll give the easy examples. The obligation would start in an easy example when the parties separate and one party leaves the house and then the other party is or leaves the relationship and the other party has the children. That's a really not easily disputed example of when child support would start. In terms of when it ends, that's where it gets a little more interesting. But the basic is that it would end at 18 if the children aren't going to post-secondary school, for example. The more in-depth answer there is we think of child support as being payable so long as the children aren't able to leave their parents' charge or kind of support themselves. But once they turn 18, we start looking into questions of, well, do they have a part-time job? How much school are they going through? What are their expenses? And the numbers aren't as clear as when they're under 18. So when child support ends gets into a more of an interesting question once we start looking at adult children above the age of 18.
Perfect. So child support, one parent paying child support to the other parent for their dependent children, if they're no longer together. At its basis, and like you elaborated on, there's two different types, Section 3, Section 7. So Gail, I'll turn it over to you. Anything to add to that as well? Oh, you're just on mute.
So in our act, our definition of maintenance, of course, is child support, but we also have expenses, which is section 7's, whether they're a fixed amount or a proportionate amount. So a fixed amount, an example would be expenses for daycare are payable at $100 per month. So we would enforce that. We also have interest defined as maintenance in our act because we charge maintenance. So in our act, it's defined as maintenance, so it's payable to the recipient. We also define in our act costs in relation to maintenance. So if a court order grants maintenance and then grants costs, we'll enforce the costs as well. Okay. Maintenance will start, we need the court order in order to be able to enforce maintenance. So the court order needs to be specific in the amount per month and the effective date as to when it starts and on what day thereafter. For example, maintenance is payable at $200 per month, effective May 1st, 2024, on the first day of the month thereafter. Very specific, easy for us to enforce on. We stop maintenance or we can step it down. So we'll stop maintenance when a child reaches the age of majority and not in school full time. And I'm not going to say 18 because we deal with other jurisdictions. So the states, other countries, so we go with their age of majority. For example, in BC, we'll go with 19. If the child's residence has changed, for example, for some reason now the child is with the payor, we will stop maintenance for that child. And when a child is over the age of majority and they have to obtain their first degree, diploma, or certificate, we will then stop maintenance for that child. Okay. A step down is when there's more than one child on a file and one is no longer enforceable and the maintenance was based on the federal child support guidelines. Then we'll step it down, for example, 3 kids down to 2 kids. And that's about it.
Perfect. Thank you. So that, and Gail, just confirm the act that you're referring to is?
The Maintenance Enforcement Act.
Perfect. Thank you. So yeah, so basic child support, that's where we're at, what it is, who pays it. We've talked about the payor and the recipient, obviously the payor, person who's paying it, recipient, person who's receiving it. And like we said, some of the different obligations that parents have and some of the different ways that MEP gets involved as well in enforcing child support payments. Okay, so with that foundation, let's move on to the question of, do we need a court order for child support? Adam?
No, you don't need a court order to pay or receive child support. So let's think about the most amicable version of this is parties separate, they understand their child support obligations. There's no question about who earns what income in a given year, and they run the calculations and they decide this is what we're going to pay and this is what I'm going to receive in child support. And so long as they're correct in the calculations, and there's never going to be an enforcement issue, and they're always going to get along, it's very amicable. You know, the recommendation would be, well, paper your transactions, make sure you're calling it child support as you're paying or receiving the child support. But so long as everyone's getting along, then you wouldn't need the court order for child support. So through that lens, you wouldn't need it. You wouldn't gain access to maintenance enforcement program or any other way of enforcing it, but it's not necessary to get a court order to meet your child support obligation or receive child support. But I don't usually see those people. Most people are coming to me because that's not the case.
So not necessary, but might be in some situations. And Gail, I'm gonna turn it over to you because I think your answer is going to be, yes, we absolutely need it for access to that enforcement piece.
So we do need a court order. However, there is another option for clients. So they avoid having to go to court and or pay legal fees. Sorry, Adam. So the maintenance enforcement program has a maintenance enforcement support agreement form that clients can fill out. It sets out how many children, incomes, how much maintenance is going to be, how much the expenses are, or the proportionate shares. They both sign the form, they send it to us, and we will file it in court for them. And then we can enforce that. We call that a MESA, M-E-S-A. Okay, but we do either have to have that or a court order. We don't do arbitration awards. We don't enforce arbitration awards, separation agreements. It actually has to be a court order.
Perfect. I posted in the chat. So Adam had mentioned it earlier, or Adam or Gail, the federal child support guidelines. And so that's what we use to calculate child support in Canada. And I've posted the calculator in the chat. So you can actually, like Adam said, you can fill it in you type everything in yourself and actually see what amount of child support is owed. And so, yeah, so in summary, don't need a child support order unless there's going to be issues with enforcement, or unless you also sign, as Gail mentioned, the MESA, the Maintenance Enforcement Support Agreement. And that form is found online, if I'm not mistaken, at the link that we would have posted in the chat for the Maintenance Enforcement Program. You're able to find that agreement there. And so, Adam, there could be, so if someone comes to you for a separation agreement, for example, then, and they need to enforce it, could they then sign a MESA in turn and take that in to have that enforced rather than having to get a court order as well? Could you go from separation agreement to a MESA?
From Gail's explanation of the MESA, you'd need both parties to sign that.
Yeah.
And so if you're in a situation where you're trying to enforce a separation agreement and they're not willing to, the other side isn't willing to pay voluntarily, I'm doubting that they'd also sign the MESA.
Right.
If they did, then of course, but it doesn't seem like that would happen. More likely, you would take your separation agreement, go to the court and say, look, we had an agreement here. Can you turn it into a court order that now MEP can enforce?
Okay.
Yep.
So there's more than one way to get at this, I guess, is what we're trying to just to show that court order may be what you need, but there's a few different ways that you can A, set out child support, and then B, also take steps to enforce it as well.
Mm-hmm.
Okay, let's move on to our next question. How can we get a court order for child support? And I'll start with you, Gail, to talk about some of the services available through the government of Alberta.
So in order to, they can put in an application on their own through the courts to get child support. That would be about the only way that I know of that they can get a court order. Or, of course, hire a lawyer and do it that way. Yeah. There is information on the Alberta .ca site to apply for child support. There is some information there.
Mm-hmm.
Mm-hmm.
Perfect. Adam, do you want to elaborate more on that process for getting the order?
Yeah. I'm not usually on this side of things, but I understand. So I'm talking about options where you don't need a lawyer or you don't need to directly go to court. And then I'll jump into how you do it when you start involving a lawyer. So I'm a bit out of my lane and I don't usually end up on this side of things, but if you're on income support, I understand that the government is able to make an application on your behalf to to get the child support order for you. So that would be one of the non-lawyer, non-you going directly through the court to get your child support order. So
May
that's
I add to that as well,
yeah,
Adam?
go for
With the income support part, they also have agreements
it.
that the parties can sign
Yeah,
that
exactly.
get filed in court. Yeah.
But if you're in the situation where it's you're not an income support and your only option is to make the application through court, Gail's right. The simple version of it is either walk into the court and start talking to the clerks to figure out which forms you fill out, and get yourself one way or another in front of a justice who's going to give you a child support order, and also an order for the other party to disclose their finances, so that you know what child support is supposed to be. Or you contact a lawyer and the lawyer gets these forms filled out for you and makes the application and represents you in court. We can go into a whole bunch of detail of what's the step-by-step of making your application. The interesting part about us having this conversation today is the court's about to change their processes for getting in front of the court to make your child support application. So a lot of the lawyers too are just about to learn the new process. And I'm not sure how much value there is in talking about the process that may change in a few days. So short answer, ask the court clerks which forms you fill out, or ask the lawyer to represent you.
And there are some pro bono or free legal services available as well. So in most across Alberta, there's several clinics that if you, depending on what your income level is, if you qualify for their services, and legal aid as well, then they can also help with some of these, some of this work as well. So we can post a link in the chat for some of the services available across Alberta as well, if you qualify for free services. So yeah, there's a range of options available: free services, doing it yourself, contacting a lawyer. And yeah, I agree, Adam, we won't dive into the nitty gritty as it's going to change, but there's lots of information available, as Gail said, online as well. So I will make sure that's available in the chat. I think Matt already posted the link for that. So there are ways to get the order. Okay, let's move on to our next question. If I'm owed child support, what are my options for collecting it? And we've started to talk about this a little bit already, but Gail, I'll let you do a deep dive a little bit more.
Okay.
Before Adam can talk about some other options.
Thanks. So depending on their relationship, of course, they could pay directly to each other, right? I would always suggest they get receipts for any payments that are made. Another option for collecting it is to register with the maintenance enforcement program. Even if the other party is in another jurisdiction with reciprocity, for example, BC, we can register any file where a recipient or the payer resides in any other province in Canada, all the states, and several other countries. So, and how it'll work is if the recipient lives in another jurisdiction, the Alberta program will enforce against the payer and try to collect the money. If the payer lives in another jurisdiction, the Alberta Maintenance Enforcement Program has no jurisdiction to place enforcement. The other jurisdiction will then try to collect the money on behalf of the recipient. When a party registers with us, they have to provide their banking information for direct deposit in Alberta. And just to keep in mind, and I'm going to start calling the Maintenance Enforcement Program MEP. That's our affectionate acronym for them. And we do not guarantee the funds. It's impossible for us to guarantee it, but we do our utmost best to collect it.
Perfect. Thank you. Adam, anything to add?
All I can really add is rare is the case that I see or someone in need of child support who has a child support order and is not being paid voluntarily chooses an option outside of MEP, because it's the least expensive. I mean, what Gail can tell me what the registration fee is. It's $25 to register, or is it anything at all?
We don't have a registration fee for the
Nothing.
initial registration.
Okay. So
Mhm.
so the cost is either nothing or next to nothing. Once you have an order and child support's owed to you, if you're thinking of going an option other than that, you're into the general collections laws. And then you're going to have to turn your order into what's called a writ. That's WRIT. And you get access to the full collection of the full collection of collection options, like garnishing wages and selling assets with a bailiff. But and there's lots more. But most people don't want to get involved in kind of pretending they're their own collection agency. And then if you involve a collection agency, there's a pretty high fee to that. Um, and if you hire a lawyer to be your collector, there's a high fee to that. So really, the best option that I've seen is MEP. And rare is the case where I hear somebody tell me that they'd like to do their own collections because the costs and it's upfront costs too. Well, I think collection agencies will take a cut at the end, but it just becomes either too much of a cut or not feasible to move forward. So most people will go through MEP to do the collections.
Mhm.
Okay, so in summary, first, you can yourself if you have that type of relationship between the payer and recipient, and they're going to pay each other on time and what they've agreed to, and everyone's amicable. But like we said, get a receipt or some sort of written proof that payment's been received, so not cash. So that's the first option. But if there are concerns with collections, or just to even just to distance the payer and recipient, right? So if they don't want to interact with each other, then MEP is usually the go-to option. It's a free government of Alberta service. And Gail, you have a bunch of tools at your disposal as well for collecting payment.
Mhm.
Like even some of the ones that Adam mentioned that you can do through a civil enforcement agency. I think MEP has some of those same powers, which then why do it yourself if MEP could do it for you?
Yeah, for sure.
So so in general, two options: yourself or go through MEP.
Mhm.
Okay, this is going to be the same questions as the flip side. If I owe child support, if I owe it now, what are my options for paying it? Anything, Gail, that you want to add on the payer side?
The payer side is that if the payer is in Alberta and they want to register with us, they have to give us automatic bank withdrawal in order for us to take it out of their account every month. Or the payer can ask for a voluntary wage support deduction notice with their employer, and then their employer would remit on their behalf. They can do it they can make payments through internet or telephone banking. They can send in, yes, we still do post-dated checks. So yeah, e-transfer right now is not an option yet. Maybe one day, just not yet. Mhm.
Adam, anything to add to that as well?
Nothing really to add. It's the same as the last question. You can pay directly, in which case keep good records, or you
Mhm.
can go through MEP, and MEP will keep those records.
And to clarify too, because we did have a question come in from the audience before the webinar, that if and Gail, you've already talked about this, but just to reinforce it, MEP gets involved if the payor lives in Alberta. So if you are living elsewhere, if you are the payor but living elsewhere, then the MEP or the enforcement agency wherever you are would be the one enforcing it. So
Mhm.
it's where the payor is that we're looking at. These are
That's
the
correct.
jurisdiction of the
For
payor.
enforcing.
For enforcing, yes.
Correct. So
Okay.
if the payer's in BC, we'll register the file there.
Okay.
then they'll enforce on our behalf on the recipient's behalf,
Okay.
kind of like the middle people.
Okay. And so if you have any questions, though, contact MEP. And I'm sure your team will be happy to answer them and get people going in the right direction. Hopefully. Perfect. Okay. Let's move on to our next question. We've talked a little bit about this. Gail, you mentioned the step down that MEP can do. But calculating child support, how can we recalculate child support? And Adam, I'll ask you to start this one.
Gosh, okay, so there's a number of circumstances I can think of. Children can age out of the child support regime. They can move into the other parent's home, which will change the child support amount. Incomes go up and down. That'll change the child support amount. In terms of the practical, well, now what? Now that the numbers have changed, or the numbers should change, how do we go about changing it? Well, if you don't have a court order to begin with and you've got an amicable relationship, you can run the calculations yourself using the online calculator and figure out the numbers, and then you just adjust it between yourselves, between the parties. If there is a court order, though, it's prudent to change the court order to reflect the new numbers. Now, what Alberta does to make this a bit easier is there's a recalculation program, so that you don't have to every single year your income changes, or every time a child ages. Well, let's just stick with the every time your income changes. You could submit your order to the recalculation program, and what they'll do is they'll receive the income information, the updated one. They'll readjust the numbers, they'll turn it into the updated court order, and then that updated court order can be sent to MEP. So that's one way to do it.
Yeah.
Yeah, the parties can register with the Alberta Recalculation Program. The order has to be eligible. So if the order imputes the payer's income, RP, the recalculation program, isn't able to recalculate on a yearly basis. One of the things clients need to understand about the recalculation program is that they do it as the date of the anniversary date of the order. For example, if the order is granted April 1st, 2024, the first recalculation cannot be done till April 1st, 2025. And then it would most likely be based on their 2022 income, because the tax season isn't over yet, April 1st. So there's some other stuff in there, but the order has to be eligible. So depending on how the order is granted, depends on whether or not it's eligible for registration.
More manual way to do it. Let's say you want your recalculation, but the recalculation program can't do it because the year anniversary hasn't passed, or if the new tax information doesn't line up with the anniversary. The more manual way is you'd make the application to court to vary your old child support order. And so part of that is you'd want updated income information from both parties. And then the court will take those numbers and generate the new numbers for you in the variation order. That'll be the new order that'll also contain your MEP clause that you then send to MEP.
Perfect. And I'm just going to pick up on one point, Gail, that you mentioned. So imputing income, for those of you who might be wondering what that is if it's not a clear, here's my T4, here's what I'm making kind of thing, and the court has to estimate it or guess it, or maybe you're a business owner. There can be instances where the court will impute or calculate that income yourself. So if that's the case, then the recalculation program doesn't work, because there's so many variables at play on what that income actually is. So recalculation program works really well, from my understanding, or if I'm correct, when it's a very simple, here's my employment income, it's gone up or down kind of thing. Perfect. Okay, we've talked a little bit about this already, this whole idea of sharing financial information. So in an ideal world, people would share it annually with each other so that they're clear on what their child support obligations are. But what if someone is not doing that in order to calculate or to recalculate child support? Adam, I'll start with you.
The court has some easier processes. In the Court of Justice, it's a request for financial information. In the Court of King's Bench, it's a notice to disclose. And at least the notice to disclose is a desk application. But essentially, it's you put in a form that says, I would like these items from the other side of this. And the items include their T1 tax returns, notices of assessment, last 3 pay stubs. They can include last 6 months of bank statements. You take this document, you have it filed, you send it to the other party, and now they have a certain amount of time to provide you with the financial information. They don't send you that financial information even in face of this document. You're able to get a court order that now requires them to provide this financial information. They don't send you the financial information in face of a court order that says they have to provide you financial information. Now you're able to make contempt of court applications, and on until you get that financial information. So that's the process to do it through the court. Judges will also, almost at the first instance, and right now it's the family docket program or family docket court. Almost at the first instance, they'll say, hey, everybody, exchange this list of items so that we can move the matter forward and figure out what everybody's income is here. So justices are well aware that they don't want to hold up their court cases by a failure of one party to disclose, and they'll use the powers granted to them to make sure that everybody's sharing their financial information, especially in a child support case.
Perfect. Thank you, Gail. Anything to add?
I do. On the recalculation program side of things, if a client doesn't provide their income within the set amount of time that we've asked for it, the recalculation program can deem it through a percentage range. For example, if it's less than 1 year that we haven't gotten it, they'll deem last year's 10% more. And it can go all the way up to 25%. And that's if income information has not been received at all for 5 or more years. So in the Family Law Act that RP follows, it allows them to deem it.
Perfect. So both some court options, and then if you're using the recalculation program, they have some powers to just deem it or assume the income has gone up 10% and all the way up to, you said, like 25%, which
Correct.
can be a lot.
Yes.
So maybe
Another thing I
worth it.
wanted to add it about RP is there's a $77 registration fee
Okay.
for both parties.
So each pays $77.
That's correct.
Okay. Is that,
Even the person that didn't register.
and is that, if that's just a one-time fee?
Every time it gets recalculated.
Every time it gets recalculated. Okay.
Mhm.
So potentially every year,
Yeah.
if you recalculate every
Yeah.
year. Okay. Perfect. Thanks for sharing that.
Yeah.
Okay, let's move on to what if someone is not paying child support? I think we've covered this quite a bit. They're not paying it at all. They're not paying it maybe in full, or they're paying it late. We've talked a little bit about some of the enforcement options already that Matt has, or Adam's mentioned some of the court processes as well. Anything to add to this question? Start with you, Gail.
I do, yes. So payers can make payment arrangements with us. So if they're not able to, they've missed payments and they can't catch up by paying a lump sum, we can make an arrangement to pay the ongoing plus some towards the arrears over time. We can also make temporary payment arrangements. For example, the court order might say it's due on the 1st of the month, but the payer has problems and can't pay it till the 15th. So we can make a payment arrangement for them to get it in a 1-month credit balance. We also have a temporary payment arrangement for less than the ongoing. So the payer's income has gone down substantially. We can make an arrangement with the payer once they give us financial disclosure and prove that their income has gone down. We can make an arrangement for less than ongoing for up to 6 months for them to give them the opportunity to get the amount changed in court or whatever means they choose to do it with. If somebody's not paying child support, we charge late penalty fees. So to try to not pay them, or get charged late fees of $40 per month and interest per month, it's best to establish a payment arrangement with us. And to do that, of course, you have to give us full financial disclosure. If someone is not paying, we have what's called a collection progression. So that's the enforcement that we place. And there's two types of enforcement. There's enforcement and then there's collection actions. Enforcement is more like suspending a driver's license. We can't get any money out of it, but it can certainly impact the payer. The collection actions, for example, we can issue a federal support deduction notice, get 50% of any type of income stream, for example, employment insurance, or 100% from what we call windfall, for example, a tax return. So that's a collection because we get money from it. So with time, as time escalates of default, of course, enforcement escalates. But at the same token, once a payer starts complying, then we de-escalate the enforcement and collection actions.
Awesome. Thank you. Adam, anything to add to that?
If you're supposed to receive child support and you're not getting child support and you don't have a court order for child support, get your court order for child support, send it to MET. If you have the child support order and you're supposed to receive child support and you're not receiving child support, you have the order, send it to MET. On the other side, is a little more interesting for me. If you're supposed to be paying child support, but your numbers are incorrect, so your income's gone down, you want to move as quickly as you can to change your court order. You want to make the application to court to say, my income is no longer my income. Can we please reduce my child support payments? The longer you wait, the more chance there is that you don't get the entire period where your income was lower adjusted. So as soon as your income changes, if you're paying child support, can't afford it, get that order changed as quickly as you can.
Perfect. So for everyone, whether you're receiving it or paying it, if something changes, someone's not paying it or your income changes, deal with it quickly. Don't let it go. Because as Gail describes, there's definitely ways that, for example, MET can escalate things that can also, pile on costs and fees. So deal with it right away. Okay, our last formal question before we get to some in the Q&A box. What if someone has not been paying the right amount? And I ask this with respect to more retroactive child support. So Adam, I'll get you to start this one.
All right. Let me clarify the question. From whose perspective do you want me to talk about?
What about from the recipient's perspective?
The recipient is not receiving the right amount of child support. Okay. So if there's no court order and there's a kind of voluntary from the payor, I'll give you X amount of dollars, but really the calculation should be X plus Y amount of dollars. And there's no court order. That's when you want to apply to court and say, this is the amount of income that the payor's been making since we separated. This is the amount I've been receiving. So this is the difference in what I ought to have been paid. And now that we know this person's income, this is the amount I'd like on a go forward basis. And so in one fell swoop, to make it a little bit oversimplified, you'll have the adjustment for the retro, and you'll also have your go forward child support. So that's how it would play out for the recipient with no court order. If there is a court order and it's been years since it's been looked at, and so the number's been wrong for years, this goes back to the earlier piece of information, which is as soon as you can, try to get that order changed. And then what you're going to do is you're going to ask the court to adjust the payment as far back as the payor's income had changed, so that you were meant to get more money. Now, there's a bit of nuance in how far back you can go, and it gets into the reasons why you waited as long as you waited to change the order. But the main message is get in there quickly to change the order so that you're receiving the right amount of income or right amount of child support, and also as much of the retro adjustment as you can receive.
Perfect. Thank you. Gail?
I don't really have much to add because the maintenance enforcement program doesn't get involved in the amounts payable as such. With the recalculation program, again, it's always based on the eligibility of the order, and then of course the incomes.
Perfect. And just to clarify, if you get, if there's a child support order for retroactive child support, can MAP enforce that retro payment as well?
Absolutely.
As well as the ongoing amount? Okay, perfect.
You bet.
Perfect. Okay, well, that ends our formal questions. I see there's several in the Q&A box, so I'm going to head over there right away. And I'll read them out, and then Adam or Gail, if whoever wants to throw an answer out, you can do that. So our first question from the audience is, can maintenance be enforced outside of this province and outside the country? Gail is nodding.
Yes.
Yes, absolutely.
Absolutely.
We've talked about that a little bit. Second question, how are childcare costs divided between separated or divorced parents under Section 7? So these are the special expenses that Adam mentioned at the beginning. So how are they divided?
You take the after subsidy amount, and then you divide that amount in proportion to the parties' incomes. So if the parties make the same amount of money, the remainder is divided 50-50, and you go from there. If somebody makes double the other party, then it's 66-33, if I've done that math right.
So yeah, add the incomes together, divide them from the total, and then that's the percentage that each person's gonna pay, or take your income and divide it by the total. Okay, next question. What are the methods of MEP collection? What would be some scenarios where MEP could not collect?
So the methods, I've already explained a few of them. So we can report payers to the credit bureau. We can suspend driver's licenses. We can restrict access to registries. We can place a writ. Well, we do place a writ, federal support deduction notice. We can do a wage support deduction notice up to 40% of gross income. We can do a non-wage support deduction notice to banks, to lawyers, if they have money in trust. If we can place a lien on property, and we can actually seize the property. So we have many ways to try to collect it. We also have deterrent fees, like we charge the penalty fees, we charge interest every month. And to try to avoid that, we try to get them to comply with their court order.
And any scenarios where MEP could not collect? I guess if they don't qualify, if they don't have the right.
If nothing in the court order is enforceable by us, then there's nothing we can do. can't really think of anything else.
Because, perfect, yeah. Like you said, MAP also works with other jurisdictions, so there's different ways
Mhm.
that it can be enforced in different provinces or states or countries.
Yeah, each place has their own legislation to follow.
Mhm.
Mhm.
Perfect, thank you. What does impute mean? I did go back and answer that, so hopefully I'm going to say, so the court calculates it or estimates it based on the information they have available to them. So I'm going to leave that one there. Okay, if child support and custody are on the same order, can the order be sent to the recalculation program to recalculate costs without opening up the whole agreement? For example, someone wants to recalculate as they should be receiving a higher amount, but does not want to risk losing primary custody if the whole order is reopened.
The recalculation program will only recalculate the ongoing. It has nothing to do with custody.
Right.
So, for example, if it's shared parenting, party or payer pays X amount and recipient pays X amount, they'll recalculate based on both incomes.
Right.
Mhm.
I'm going to pop over to a question. I'm just going to see if it actually got put into here. So there's a question in the chat. Can I clarify that all this information is based off of one parent having the children 60% or more? Is the information completely different if the parents have a 50-50 split? So I guess the question would be, what is the impact of parenting arrangements on how we calculate child support? Adam?
I'm glad that got brought up.
Mhm.
So the child support regime changes when you're in a shared parenting arrangement. So if what we were talking about was 60% or more, and lawyers often refer to it that as primary care. If you're in the middle ground where you have 40% and 60%, or what is it? Let's say 41 and 59%. Then both parties owe child support to each other. So you run the same calculations. And this is let's call it the oversimplified version. You run the child support calculations, and if both parties make the same amount of money, then they're going to owe each other the exact same amount. And so child support will be zero. But if one party makes more than the other party, the net will be some amount payable to the party who makes the less amount of money. That's the set off method that the court employs. You're not necessarily only going to use the set off method if you're in a shared parenting arrangement. That's just a kind of easy starting point. You can also look at the full the full scope of the situation between the parties, including, well, who's buying the winter coats every year? Who's paying for the big expensive items every year? And the court will take that into consideration when deciding, should we do a straight set off of child support, or should there be a more nuanced approach to determining the right number? It all falls under Section 9 of the guidelines. And Section 9 lays out a few of the different factors that the court will take into account. But the easy one to think about, or the starting point lawyers usually use, is that straight set-off method.
Perfect. I'm just posting a link in the chat. So one of the resources that CPLE has available right now is a booklet called Financial Support. And on page 9 of it, it talks about those different, primary care, shared parenting, split parenting, and how you can calculate support in those different situations. So let me just post that in the chat right now. As a resource as well. Kind of, it summarizes exactly what Adam just mentioned. So thanks for sharing that, Adam. Okay, next question. Will MEP recalculate amounts every year after taxes, or is it only ever calculated through the recalculation program?
It's only recalculated through the recalculation program. MEP does not recalculate at all.
So you have your MEP, you go to the recalculation program, get your updated
Mhm.
number, it goes back to MEP, MEP will enforce that payment.
Exactly.
Perfect. Why does MEP not follow through with collection actions if the payer is on AISH?
Well, that's a good question. It depends on circumstance. There's no black and white answer to that. It depends on circumstance. When a payers on AISH, they still might have the ability to pay the ongoing plus some towards the arrears, because a payer can then still work and make a certain amount of wage per month before it affects their budget with AISH. So we could still try. But typically, AISH income is very low, and we'll make as small of an arrangement as we can, just so they avoid those penalties and that interest that's accumulating. But again, they still would then need to take it back to court. But it depends on the file. Every file is different, so there's not a black and white answer to that one.
Perfect.
Mhm.
Thank you. I'm moving quickly because we're running out of time. We might not get to all the questions, but we'll try and get to as many as we can in the next 3 minutes. I work as a frontline support with survivors of family violence, and withholding child support is a common form of financial abuse. I'm curious to know if MEP has guidelines about when they take more intrusive collection, enforcement or collection action. Does this occur after 3 times of not making payments, for example? And they're also wondering if anyone has advice for the person who is not receiving the payments in terms of keeping documentation of this. So how should they be keeping records of the non-payment?
The non-payment, if they're registered with us, we keep an accounting of the file. So they can always ask for a statement of their account. As far as other collections, we can also take payers to court for default hearing. If we can prove that they have the means to pay, we can then put in an application for a default hearing. The justice will then set the amount payable towards the arrears based on the information provided. We can also seize LIRA, RSPs. That gets a little more extensive work. So we have a special investigations unit that handles those types of collection actions. I'm hoping that answered the question.
Yeah, I think so. Unless the person who asked if they have any other follow-ups, let us know. But I'll move on to the next question here. I would say, how long is a court order valid for?
Short answer, forever. This specific court order from 2014, it's still valid.
It might not be up to date, but it's still valid.
It's still enforceable.
Yeah. Okay, what safety measures are taken when registering for MEP if there's a history of domestic violence?
We'll put an alert on the file that there is a history of violence. We never share personal information with either client, so we make sure their information is secure at all costs.
Okay.
Mm-hmm.
There's a question here about if there's a pattern of complying and then not when enforcement is constantly escalating and de-escalating. Is there any option available to dissuade a payer from doing this? I think you've already talked to Gail about some of the penalties and stuff that you can implement, and that would just be a case-by-case basis, I'm guessing.
That's correct.
Okay. Are parenting parties ever mandated to try mediation prior to getting a lawyer?
Not prior to obtaining a lawyer, but there's a movement in the court to asking parties to try mediation before they start using the court processes. But you can attend mediation with a lawyer.
Perfect. Okay, 2 more questions. When talking about shared parenting, is 60/40 counted by overnights or some other method? Adam?
The courts really dislike getting into this issue. And not many cases fall on that. Is it 60? Is it 61? Is it 59%? But there's certainly a motivation for parties to think about those numbers. The latest I've seen, and this creates a lot of homework, is to count the hours in the days that you have the children. The overnights, if they're sleeping at your home, count as towards those hours. Where it gets a little bit interesting is when the children are at school, where those hours count towards. And the latest I've seen there is, well, who would the school call and who would be available in the event of an emergency where someone had to pick up the child? So there's, and I mean, those are just some examples of the more gray areas. So when it gets to that, is it 59? Is it 61%? There's let's say a lot of room for debate, and the courts, they're not too happy to engage in that debate because they'd rather see child support being paid and parties working things out. But I understand why the dispute exists.
Perfect. Okay. Very last question. The previous asker was just clarifying if there's a set protocol for when Matt moves forward with taking more intrusive action, or is it just case by case?
It's case by case. I do want to also say that there are times when if the payer, for example, makes a payment arrangement 3 times with us and then doesn't comply all 3 times, we can then make the actions the payer has to follow longer. For example, we need 4 payments, consecutive payments, in order to remove enforcement. So we have that discretion.
Perfect.
Mhm.
Okay, we've gone a couple minutes over, but thank you everyone for your questions. Thank you, Adam and Gail, for joining us today and providing some excellent information to everyone who joined us. Just a reminder, stay connected with us so you can find our information, again, free legal information about family law on a variety of topics at cplea.ca. We also have a newsletter you can subscribe to. We send that out monthly, so you can get updates on what's new with us. And we also share about some of the changes in the justice system. And then follow us on social media. We're on Twitter, Facebook, Instagram, YouTube. You can find us there. I'm going to wrap it up there, but I will say as well, I think Matt's probably posted it in the chat, or when you leave today's webinar, you'll be prompted to complete a short survey. Like I said at the beginning, please just spend 30 seconds, let us know how we did. We really appreciate the feedback. Other than that, I'll let you go and say thank you again, Adam and Gail, and have a great rest of your Thursday.
Thank you.
Thank you. Have a great day.
Bye-bye.
Hi, everyone.